Chapter 6 Departmental Legislation. There are two kinds of delegated legislation, one based on the prerogative of the Crown, and the other deriving its force from some Act of Parliament expressly giving power to legislate with regard to a particular matter either to the King in Council, or to a public minister or department, or some other authority. The term prerogative comprises such powers as are exercisable by the executive government without express authority from Parliament. There are many matters which were formerly the subject of prerogative legislation exclusively, but which are now dealt with by Act of Parliament, and it is a principle of the Constitution that, when Parliament has given express power to legislate in reference to a particular matter, and has provided by whom and subject to what limitations the power shall be exercised, the prerogative power of legislation in regard to that matter is superseded. At the present day, prerogative legislation is chiefly concerned with the Army and the Navy, the civil and diplomatic services, and the government of Crown colonies, dependencies, and the Channel Islands. All prerogative legislation is in theory subject to review by the courts of law, and may be treated as void if found to be ultra vires. The largest and most important part of the statutory delegated legislation is comprised in what are known as statutory rules and orders. All of this legislation derives its force from the Act of Parliament by which the legislative power is given, and not from the authority by whom the power was exercised. Consequently, in order to ascertain whether a particular statutory rule or order is intra vires or ultra vires, it is necessary to look at the terms of the authorising statute to see whether the legislating authority has acted within the limits of its mandate, and, to speak generally, the validity of much statutory delegated legislation may be judicially challenged, and, if any such legislation is held to be invalid, it may be treated as void or quashed. Expedients have, however, in many cases been resorted to for the purpose of ousting this power of judicial review and rendering statutory rules and orders unchallengeable as Acts of Parliament themselves, and of course no court can question the validity of an Act of Parliament. These expedients are referred to elsewhere. Save that their validity can in many cases be judicially questioned, statutory rules, regulations and orders are as much part of the law and as effective as Acts of Parliament, and, in the matter of quantity, this kind of delegated legislation has in recent years enormously exceeded the amount of direct legislation by statute. Nor is such delegated legislation by any means confined to matters of detail or of small importance. Very wide and general powers are sometimes given to a public department to make regulations for the purpose of carrying this Act into effect, and the Act itself may merely state the subjects in regard to which the regulations may be made without any further indication of the kind of legislation intended to be authorised, this crucial matter being left entirely to the discretion of the department. Sometimes power is given to the rule-making authority to revoke or alter express provisions of the statute under which the regulations are made in regard to matters of prime importance. It is provided by Section 32, subsection 3 of the Interpretation Act 1889 that where an Act passed after the commencement of that Act, quote, confers a power to make any rules, regulations or bylaws, the power shall, unless the contrary intention appears, be construed as including a power, exercisable in the like manner and subject to the like consent and conditions, if any, to rescind, revoke, amend or vary the rules, regulations or bylaws, end quote. It would appear, however, that this provision does not apply to statutory orders, as distinguished from rules, regulations, and bylaws, and therefore, unless a power of revocation or amendment is expressly conferred, an order of a legislative character cannot be revoked or varied by the authority by whom it was made. It is tolerably obvious that the system of delegation by Parliament of powers of legislation is within certain limits necessary, at least as regards matters of detail, because it is impossible, if only for want of time, for Parliament to deal adequately and in detail with all the matters calling, or supposed to call, for legislation. Indeed, without a drastic alteration of its methods of procedure, it would be impossible for Parliament to deal adequately with even a comparatively small part of the present-day volume of departmental legislation. It may also be conceded that the system, if not abused, and subject to proper safeguards, may have its uses. It is the abuse of the system that calls for criticism, and perhaps the greatest abuse, and the one most likely to lead to arbitrary and unreasonable legislation, is the ousting of the jurisdiction of the courts. A valuable security against hasty and unreasonable legislation is a provision which is sometimes inserted in statutes giving legislative powers, requiring that, before the powers are actually exercised, persons interested shall be notified and given the opportunity to make objections or suggestions, and in some cases requiring a public inquiry to be held. Section 1 of the Rules Publication Act 1893, 56 and 57 Victoria C. 66, provides as follows. 1. Subsection 1. At least 40 days before making any statutory rules to which this section applies, notice of the proposal to make the rules, and of the place where copies of the draft rules may be obtained, shall be published in the London Gazette. Subsection 2. During those 40 days, any public body may obtain copies of such draft rules on payment of not exceeding 3d per folio, and any representations or suggestions made in writing by a public body interested to the authority proposing to make the rules shall be taken into consideration by that authority before finally settling the rules, and on the expiration of those 40 days the rules may be made by the rule-making authority, either as originally drawn or as amended by such authority, and shall come into operation forthwith, or at such time as may be prescribed in the rules. Subsection 3. Any enactment which provides that any statutory rules to which this section applies shall not come into operation for a specified period after they are made is hereby repealed, but this repeal shall not affect Section 37 of the Interpretation Act 1889. Subsection 4. The statutory rules to which this section applies are those made in pursuance of any Act of Parliament which directs the statutory rules to be laid before Parliament, but do not include any statutory rules if the same or a draft thereof are required to be laid before Parliament for any period before the rules come into operation, nor do they include rules made by the Local Government Board for England or Ireland, the Board of Trade, or the Revenue Departments, or by or for the purposes of the Post Office, nor rules made by the Board of Agriculture under the Contagious Diseases (Animals) Act 1878, and the Acts amending the same. Subsection 5. This section shall not apply to Scotland. Subsection 6. In the case of any rules which it is proposed shall extend to Ireland, publication in the Dublin Gazette of the notice required by this section shall be requisite in addition to, or, if they extend to Ireland only, in lieu of, publication in the London Gazette. End quote. Section 37 of the Interpretation Act 1889, referred to above in subsection 3, provides that where an act passed after the commencement of that act, quote, is not to come into operation immediately on the passing thereof, and confers powers to make any appointment, to make, grant, or issue any statement, that is to say, any order in council, order, warrant, scheme, letters patent, rules, regulations, or bylaws, to give notices, to prescribe forms, or to do any other thing for the purposes of the act, that power may, unless the contrary intention appears, be exercised at any time after the passing of the Act, so far as may be necessary or expedient for the purpose of bringing the Act into operation at the date of the commencement thereof, subject to this restriction, that any instrument made under the power shall not, unless the contrary intention appears in the Act, or the contrary is necessary for bringing the Act into operation, come into operation until the Act comes into operation. End quote. It will at once be observed that the foregoing provisions of the Rules Publication Act have a very limited operation. First, they apply only to statutory rules made in pursuance of an Act which directs that they are to be laid before Parliament, and it is only in a comparatively small number of the statutes giving power to make statutory rules that there is any such direction. Secondly, it is doubtful whether the provisions apply to statutory orders, as distinguished from statutory rules, regulations, and bylaws. Probably they do not. See the definition of statutory rules for the purposes of the Act below. Thirdly, the provisions do not apply if the rules or a draft thereof are required to be laid before Parliament for any period before the rules come into operation. Fourthly, the provisions do not apply at all to rules made by the Local Government Board, now the Ministry of Health, the Board of Trade, or the Revenue Departments, or by or for the purposes of the Post Office, nor to rules made by the Ministry of Agriculture and Fisheries under the Contagious Diseases (Animals) Acts. Fifthly, the provisions of the section have been expressly excluded by various acts conferring rule-making powers. Lastly, even when the section does apply, its provisions may always be evaded by a certificate of urgency, section 2 of the Act providing that, quote, where a rule-making authority certifies that on account of urgency or any special reason, any rule should come into immediate operation, it shall be lawful for such authority to make any such rules to come into operation forthwith as provisional rules, but such provisional rules should only continue in force until rules have been made in accordance with the foregoing provisions of this Act. End quote. It is to be noted that provisional rules not only come into operation forthwith, but continue in force until rules have been duly made in accordance with the provisions of Section 1. If, therefore, rules are never made in accordance with those provisions, and there is no obligation to make rules in accordance with them, the provisional rules will remain in force indefinitely, and provisional rules are as valid and effective in every respect as if the provisions of Section 1 of the Act had been complied with. A provision which is sometimes found in statutes giving power to make regulations is to the effect that the regulations shall be laid before each House of Parliament as soon as may be after they are made, and that if an address is presented to His Majesty by either House within a certain number of days, usually 20 or 30 days, on which that House has sat, next after any such regulation is laid before it, praying that the regulation may be annulled, His Majesty in Council may annul the regulation, and it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder. In such a case, the regulations take effect as soon as they are made, and the provisions of Section 1 of the Rules Publication Act therefore apply, unless they are expressly excluded or the regulations are made by one of the excepted departments. Regulations are very rarely annulled in pursuance of such a provision, but this fact does not necessarily mean that they are unobjectionable. It may be that they escape because no Member of Parliament has taken the trouble to weigh and consider them. The liability to annulment may, however, have the effect of making the legislating department somewhat more careful than it would otherwise be. The following are examples of other types of provisions to be found in statutes of the kind under consideration. A. Before the order comes into force, it shall be laid before each House of Parliament for a period of not less than 30 days during which that House is sitting, and if either of those Houses before the expiration of those 30 days presents an address to His Majesty against the order or any part thereof, no further proceedings shall be taken thereon, without prejudice to the making of any new order. Here the order does not come into operation until the expiration of the 30 days, and the provisions of Section 1 of the Rules Publication Act have no application. B. The order shall be laid, as soon as may be after it is made, before each House of Parliament, but shall not come into operation unless and until it has been approved, either with or without modification, by a resolution passed by each such House. When there is this provision, the order is in the nature of a proposal, which has no effect until it has been approved by resolution of both Houses. It is nevertheless delegated legislation, because a resolution of both Houses is not equivalent to an Act of Parliament, and, in the absence of provision to the contrary, the order, notwithstanding a resolution of approval, may be open to judicial challenge on the score of ultra vires. Until 1890, there was no regular publication of statutory rules and orders, and often the only means of finding them was by a search through the London Gazette. Since that year, they have been printed and published on a systematic plan and placed on sale. There are annual volumes, published by authority, containing every statutory rule and order, other than those of a local, personal, or temporary character, issued during the year, and also containing classified lists of the local orders of the year, and tables showing the temporary orders which have come into force and expired during the year, and the effect of the year's rules and orders on statutes and on the statutory rules and orders previously in force. There is also an edition in 13 volumes, issued in 1904, of The Statutory Rules and Orders Revised, which contains all the statutory rules and orders, other than those of a local, personal, or temporary character, which were in force on the 31st December 1903. The official printing and sale of statutory rules and orders are now regulated by the provisions of Section 3 of the Rules Publication Act 1893 and the regulations, dated the 9th August 1894, made thereunder. Section 3 of the Act is as follows, quote, 3. Subsection 1. All statutory rules made after the 31st day of December next, after the passing of this Act, shall forthwith, after they are made, be sent to the Queen's Printer of Acts of Parliament, and shall, in accordance with regulations made by the Treasury, with the concurrence of the Lord Chancellor and the Speaker of the House of Commons, be numbered and, save as provided by the regulations, printed and sold by him. Subsection 2. Any statutory rules may, without prejudice to any other mode of citation, be cited by the number so given as above mentioned and the calendar year. Subsection 3. Where any statutory rules are required by any Act to be published or notified in the London, Edinburgh, or Dublin Gazette, a notice in the Gazette of the rules having been made, and of the place where copies of them can be purchased, shall be sufficient compliance with the said requirement. Subsection 4. Regulations under this section may provide for the different treatment of statutory rules which are of the nature of public acts, and of those which are of the nature of local and personal or private acts, and may determine the classes of cases in which the exercise of a statutory power by any rule-making authority constitutes or does not constitute the making of a statutory rule within the meaning of this section, and may provide for the exemption from this section of any such classes. Subsection 5. In the making of such regulations, each government department concerned shall be consulted, and due regard had to the views of that department. End quote. Section 4 of the Act defines statutory rules as meaning rules, regulations, or bylaws made under any Act of Parliament which a. relate to any court in the United Kingdom, or to the procedure, practice, costs, or fees therein, or to any fees or matters applying generally throughout England, Scotland, or Ireland, or b. are made by Her Majesty in Council, the Judicial Committee, the Treasury, the Lord Chancellor of Great Britain, or the Lord Lieutenant, or the Lord Chancellor of Ireland, or a Secretary of State, the Admiralty, the Board of Trade, the Local Government Board for England or Ireland, the Chief Secretary for Ireland, or any other government department. End quote. And rule-making authority as including every authority authorised to make any statutory rules.